Okay, so in addition to the fact that it was based on empirical findings, those findings then fed into several, and during 3 years, so quite a few sessions, physical sessions and calls where the findings were discussed, debated. We can call those discussions scientifically, and this is mainly borrowed from the medical profession, a consensus sessions that eventually lead to consensus statements by leading experts discussing comprehensively a particular topic. And we know that there's a lot of in common between bankruptcy and especially restructuring proceedings and medical proceedings. So I think that this research is specifically strong, and this gathering adds to its strength. Now to SMEs, Ignacio will start with presenting the authors, the project's authors' thinking about SMEs based on the findings and discussions and the debate, and also against the backdrop of the directive that, as Michaela mentioned in the morning, one of the main aims of the directive was to address the special case of, or the problem, the challenges faced by SMEs. But at the end of the day, the directive didn't provide specific provisions for SMEs. And one of the issues to discuss in this panel, I think, is to what extent this is the right approach to provide rules for the larger entities with the hope that over time, hopefully, those procedures will also be used, at least to some extent, by SMEs, or whether the right approach is actually to think small first and shape a certain and provide certain procedures that are more devoted to the special case of SMEs. So Ignacio will start with explaining the findings and the suggestions, the conclusions of the debate between the project authors. What do they suggest for SMEs? And then we are also very delighted to have in this panel two very distinguished discussants. On my left, Judge Andrea Csuke from Hungary, and a managing partner, Stathis Potamitis from Athens in Greece. And starting with Andrea, and afterwards Stathis will react to Ignacio's presentation, obviously drawing on your perspective and national experiences, but also going beyond what is the current present situation in your countries to try and think to the future, how we can perhaps improve the system for SMEs. So we will try to be focused, and also in terms of the time, Ignacio will take about 20 minutes and then reactions of about 10 minutes each, so that we will have enough time to get comments from you and also to respond to these comments hopefully comprehensively. So over to you, Ignacio.
Thank you. You will see that one of the key parts of what we're going to introduce here, propose, is an option called doomed to fail, which is when there is a possibility of a small entity trying to propose a plan, and creditors from the very beginning say no. So that goes straight into liquidation. So very quick. Having heard Andrea and Michaela on what can be done, it seems that this presentation is doomed to fail already, but nevertheless, perhaps for the future, or just for the fact that we've been working on it for a long time. I should start by thanking people very quickly. Many of the ideas here, what I will try to do quickly is first present the results of the review of the research that we have all conducted, after which we will identify the main problems, and then we will propose a solution that we think tackles those problems. This solution is in a small part original and is largely the result of the intellectual activity of a number of people who are not here. Some are here. Irit is here, who is of course part of the Stefan Madaus is here, Professor Gianni Sara, Professor Ron Davis, Professor Alberto Mazzoni, and Judge Barbara Romain have also been part of the intellectual process of creating a procedure that we're going to put forward, and they deserve all praise, much more than me, the one who's presenting it. Second, I cannot avoid but to reiterate the gratitude to a wonderful colleague, a wonderful person, a wonderful academic that couldn't be here today, which is Wolfgang Zenker from the German team, who has been absolutely instrumental in doing, in helping us draft the results and reach the main results, not only in this section, but in every section of this project. Having said that, before I get very emotional, I will move on to the research. These are the, if you can read, the main results that we have. We are proposing a procedure, actually, for MSMEs. The idea will be to include that procedure as part of the directive, at least for states to think about it and perhaps implement it. Unfortunately, we have not been able to get hard copies of those pages with the procedure, but we will make it available online to all of you very, very soon. And whenever necessary, I will read the article. It's 1, 2, 1, 2, 3, 4 articles, but very long articles, I must say. Article 9, USCC type. I don't need to explain to everyone here today how important MSMEs are. We are actually focusing not on the whole MSME section, but on the micro and small entities. We really want to place the attention on the creation, perhaps, of a procedure for micro and small businesses. Let's forget about medium enterprises, because they're well covered by the directive. Let's move on to the smaller section of that. The importance of that is absolutely huge, cannot be overestimated. The truth is that well above 95% of businesses are micro and small businesses in every jurisdiction of the European Union. There's no difference here, across the board. And if you look at the fact that not only the directive, but also the vast majority of national insolvency regimes of member states do not care to create an ad hoc proper insolvency or procedure that tackles the financial distress of these entities, you can only be surprised about it. What happens in practice, according to the research and data that's actually available on Eurostat and other open databases, is that most MSMEs that are in trouble, micro and small businesses, just die on the beach. They just die, full stop. No one really cares about them. They just disappear, or this Phoenix syndrome problem happens, and most of them are just left to die, full stop. And it's only when there is a relatively proactive tax agency that says, hey, these guys are inactive, let's do something about it. Of course, when they get to that point, you can't even trace the guy who was behind the company, so it's a complete waste. And then there is a portion which is properly insolvency liquidated, uses properly insolvency procedure, and the percentage of breakup piecemeal liquidations in these cases is absolutely astonishing, well above the 90-something% that can be predicated of all companies. If we look at the systems of the UK, Spain, Italy, and Germany, surprisingly to me, because as an academic, I had always thought that, the UK, Germany, wonderful places where, everyone reaches an agreement and there are no liquidations. The percentage of liquidations is the same as in every other country. It's just the same. And if we look at the liquidations, within the liquidations, there are piecemeal liquidations, the vast majority of those are small and micro enterprises. So the chances of having a restructuring, we have found out, is much larger, the larger the company and the bigger the business. So we really have, this is the layout of what we've been able to see, and this is what we have in front of us. The system, of course, creates many problems in terms of transparency, legal certainty, value destroyed, and also creates very strong ex-ante corporate governance problems. So we really should do something about this. What to do about this? Sorry, I still haven't finished with the results of the... Oh, thank you. More findings. In the vast majority of cases, debtors, MSMEs, seek advice way too late. And if they seek advice way too late, they also restructure way too late. What are the causes that we have identified? And this applies across the board in all 4 jurisdictions. There is not always adequate advice from external advisors, in most cases because there is no such advice at all. These entities have poor financial information very often, and therefore it's difficult to identify early when the problems appear. And once they have appeared, it's much more difficult to restructure a business because there is not adequate financial information. So banks are not so willing to restructure, and neither are creditors. There is no monitoring by creditors. This is a big problem, and it's on the side of the creditors. There is very little banking follow-up monitoring of SMEs, especially of micro businesses. It's just not worth it for them. So when it comes to early identification of the problems, if we have a large entity, it's okay because we've got banking covenants, but we don't, or many jurisdictions at least don't, when it comes to very small businesses and micro businesses. So we lose that side, which would make things easier to identify from the beginning, and therefore at a time when value can still be preserved. Then we have the personal side to it, which I have put in a different type of letter. Of course, the lack of insolvency culture, formal proceedings want to be avoided by small businesses because most of them are family business. They all have all the eggs in the same basket, so they have heads in the sand. The ostrich effect, as we say in Spain, which basically means when you have a problem, the head goes down, you don't just carry on, externalizing the risk of your creditors. So you basically do everything to try to file for insolvency or use insolvency and even pre-insolvency proceedings. This is a fact that we have identified everywhere, and we doubt this comes as a surprise to you. Contractualized mechanisms, whenever they exist, are not used. Let me give you the Spanish example. Spain has a good system on the face of it, only for MSMEs, with very low cost, templates, the possibility to restructure fully out of court with the implication of mediators and chambers of commerce. Is not working at all, and it's not working but not because the system is not good. It's not working because it has 2 fundamental flaws. First, it does not concern public creditors. If you don't restructure public creditors, public claims, when you are an SME, then why bother use it when a vast majority, or at least a large portion of your debt, is owed to the tax revenue office? Second, and this is very important and controversial, there is some sort of disagreement between the team as to whether this is actually a problem. I think it is very clearly. Whenever there is a different majority threshold out of court and in court, we identified that small entrepreneurs, will simply not use out-of-court proceedings because they needed to reach a 75% majority, while within insolvency proceedings, they would do with a majority of 51%. So it is very common in countries, in member states even, to create different thresholds, which are more difficult to reach out of court than in court, which creates, of course, a forum shopping problem. And this needs to be tackled. If we want to foster out of court, this is one of the things we need to think about. And then there's a problem with creditors. They are not interested. There is passivity. So creditors don't really, especially financial creditors, don't really engage in negotiations beyond pure bilateral rescheduling with additional guarantees. And this seems to be a problem. This is the result of the analysis. Let me move then quickly, because I'm exhausting my time already, to what we would suggest as alternative. We would suggest a special procedure for micro and small entities. So it's very difficult to change here and there as well. Here. I think this slide basically summarizes everything. We would propose to rethink, for example, most of the concepts of proceedings that we have in mind. We would propose to overcome the dichotomy between out of court and in court by proposing a procedure that is essentially between private parties and which only comes to court whenever necessary. So it is both an out of court and a potentially in court procedure at the same time. This is not a structured out of court and a structured in court system. It's rather a structured out of court, privately dealt with very low institutional involvement, but the parties can resort to insolvency whenever necessary. This might seem like a bit odd, and it's just new rather than odd. But, and of course, immediately it will spring to your minds, well, there are a lot of problems with this, because many people will resort to the court anyway. I'm not so sure about this. But let me concede to you that that happens, and that 30% of proceedings are actually, even though they're completely out of court and are started informally, someone raises the flag and says, let's go to court because I don't trust anyone here. We still have solved the problem of 70% of the cases, and that is a lot. And that takes me, this idea sprung up to our heads in a way, looking at something that's happened in, I believe it's Austria, and I apologize because I don't really know the system very well. I think it's in Germany they're also thinking about it, if they don't have it already, which is, it concerns individual actions. And it's, there is a rule according to which if you file in court and the defendant is notified and defendant doesn't turn up and say anything in 5 days or in 7 days or whatever, that's automatically, there is a sentence in favor, there's a decision in favor. And surprisingly, almost 80% of the cases are solved that way. So you just save so much litigation in court, and you remove a backlog, a huge backlog of cases from your court system, simply because the defendant or the debtor, alleged debtor, is not interested, doesn't turn up. So caveat creditor, that's your problem if you don't turn up. We've got a judgment against you. You could have come up. So that evidence suggests that passivity should and can and should be used in the correct direction, which is not to stop proceedings and lengthen them and burden the system, but rather, look, you don't care about your issues, sorry, you lost it. And a good portion of those will be out, and I don't see any constitutional problem with this, because after all, they are notified, and they could have come up and say something about it, but they don't. So this is one of the elements that lie under the ideas of this procedure. Another one is, one of the main tenets is that we profoundly believe those that are in the best situation to make decisions are the parties. And therefore, it's up to the debtor and especially creditors to decide not only what exit the business should have in a given situation, but also what type of protections and what type of procedural elements we want in the procedure to be used. So with this view in mind, what we propose is the possibility for micro and small businesses to access either a continuation or a liquidation, which would be a very raw procedure, very quick, with minimum court and institutional involvement, but giving the parties the possibility to ask for protection, ask for legal measures, and ask for institutional involvement if they so request in an objectively adequate manner and justified manner. I must say that our proposal is not merely procedural, it needs to tackle behavior of creditors and behavior of debtors. So it's an all-around comprehensive strategy to address MSME problems. We have here don't we? Oh, there you go. Stefan Madaus might be familiar with this. Does it ring a bell? I changed the colors though. So this is this is how it would more or less look. You have one way, motion to file for liquidation. Our idea is that the vast majority of these proceedings will be liquidation proceedings. Will be very quick liquidation proceedings. And you'll all think, yeah, but these are family business. Why would they liquidate? Because it is a fast track to discharge. A fast track to discharge, to the extent that is possible, of course, and that has not been fraud or misbehavior. But that is an extremely power incentive to go to a straight liquidation. And then we have, when the family business thinks that they can still continue and there's some value to it, then they file for a rescue plan or a continuation plan, as we call it in the law or in the proposal of text proposal, that will lead to a plan confirmation. What are the options that can be added to this raw, quick procedure to a liquidation or to a continuation of the business? Debtors can, we have proposed, or we propose that debtors can, for example, ask for a mediator if necessary. A mediator that will help them deal and negotiate with creditors. We have the Spanish experience, which is not pure mediation, but it's something like that. And that part has worked relatively well because the debtor doesn't really know how to handle. It will likely have very few creditors. Think of a small business with a simple business model with 5, 6, 7 creditors, no more than that. What separates the debtor from creditors is the fact that creditors feel let down and therefore they have a personal issue with the debtor. This is what happens in reality. So this mediator just is able to convince or might be able to convince and say, look, this is what happened is no one's fault and let's work out a better solution. That's a possibility. Of course, it's only a possibility so long as someone is going to pay for that mediator. If there is no money for the mediator, there is no mediator. And then even the creditor action moratorium would be also an option. You might think, why would a debtor not ask for an automatic moratorium or stay in case of liquidation? It might not have the interest to it, because what if all of its assets are already allocated to secure creditors? Why would you want a stay if you're going to liquidate? Why would you even need a liquidator if what you have is you want to liquidate and all your assets have been pre-assigned by means of collateral to creditors and there are no other creditors? Or at least there are no other creditors in the money. Those are a good chunk of cases as well. Let's just get rid of those very quickly. Of course, the rest of creditors can object to that, but they have to object. Unless they object, this will be a very expedient, very quick way to get rid of this. In the case of a motion to file for a rescue plan, the creditors' initiated modules, and I will fly over them, will be mediation or IP involvement in case they need that the debtor that continues to operate needs supervision, or even removal from management and substitution by a professional. This is not per se something that's going to happen. This will only happen if sufficient number of creditors say, we want this to happen. We need a professional to monitor. Of course, this will only happen as well, even if they request it, if someone's going to pay for it. It might be the debtor if there's money, and if it's a continuation procedure, it will be the debtor. But in some instances, it might even be in the interest of creditors to do it. Usually, in this type of proceedings, the de facto rule would be for the debtor to continue in possession and continue to operate the business, but creditors can request that this debtor's management powers and its ability to incur new liabilities are restricted and they're limited. But they have to ask for it expressly. And finally, they don't have to waste time. If a sufficient amount of creditors believe that there is no objective prospect of a continuation plan, they think this is doomed to fail, and this all goes straight to liquidation. One final word would be simply to say that Hello, is it moving?
Thank you.
Yeah, thank you. Right, well, very quickly, what I wanted to say is that the institutional involvement in this procedure is very limited and is potential, as you can see. But what we need to, what the member state will need to sort out is whether you want a court or you want an administrative agency to do it. At least for some of the tasks that we've seen here, maybe an administrative agency is more efficient than a judge. The judge will be more efficient and will do the job better when it comes to finally confirming the right and right of the debt, or to affect the legal rights of the parties in a manner where that in some countries only a judge can do. But for the functional part and for the instrumental part of this procedure, an insolvency agency would be probably more efficient and quicker and better than a court. Because one of the objectives of this is to remove cases from the court system, to improve generally the use of those of the courts. And finally, we have, and this is the last thing, one of the main problems of MSME insolvency is creditor passivity. Creditors are just not involved in it. For that, we have provided some possible solutions. I will just refer to two of them. One of them is the deemed consent rule, which of course you might be familiar with, which is basically if you don't vote, you are deemed to vote in favor. So that fosters active participation by creditors who will just, if you don't like the plan, they just have to come and vote against it. And the scream or die rule, which is whenever there is an entitlement of a right assigned to a certain creditor, if they don't oppose to it, they will be deemed to have accepted the classification of the claim, the amount of the claim, and everything that concerns the claim. So they need to be proactive about it. Otherwise, they will just be frozen in their rights. And this is a very quick overview of this. I know this unpacking of classical procedures, adding flexibility and allowing for the possibility to add them or not, sounds a bit odd and might present some German constitutional law problems. But apart from that, I think it merits some discussion.
Thanks, Ignacio. So the suggestion is to introduce or to consider introducing specific procedures for the micro and small enterprises that are very simple, or at least could be very simple, may not require a court, may not require a supervisor, and may not require a stay, etc., and can work even when the creditors are passive, although the parties can pick up various tools. It could be the debtor that will pick a certain tool, or the creditors, depending on the circumstances and what the parties wish to do. And I believe that this approach isn't doomed to fail. Perhaps it may not be adopted fully in the spring in the directive, but there's still, I understand, some room for accommodating the SMEs better. But certainly member states themselves could consider introducing certain procedures for SMEs. The directive will not prohibit that. So your reaction, Andrea, first, can that work?
This one? Okay. So thank you very much. I'm very ashamed myself in the name of Hungary, because unfortunately in Hungary the entrepreneurs, the individual entrepreneurs are not, can't be debtor, because they are out of this insolvency system. So they can be So there can be a party against the enforcement, judicial enforcement, but they can't escape from the debts. during insolvency proceedings. So individual entrepreneurs, I can't say anything about individual entrepreneurs. Meanwhile, it would be a very, very important thing to create such a proceeding for them, because there are many of them is in a very big trouble in Hungary also. So the other bad news that there is no special regime for SMS in Hungary too. So the common rules have to be used for them. But
this is great news, because if the directive comes into play, you will have to...
Oh, yeah, no. So this is why I checked all, I've read all of the text what I've got in email. I am a fresh meat in this project, because I didn't know about this project as before, but I read it, and I tried to check it from a judge point of view. Is it whether the definitions are unambiguous? I could use them, or what happened with it? And I try to explain to you what I found in these texts. So the first of all, that I think that this group should suggest the Commission, the European Commission, to put other new definition into Article 2 of the proposal. First of all, I found out, and I will send to you, Lorenzo, my little written text about the meaning of the liquidation. What is liquidation? Because I think that we use the liquidation word in different meanings. Because liquidation can be selling the assets, and liquidation can be a proceeding. For example, when Hungarian is translated into English, or vice versa, the liquidation is a proceeding in which the debtor is insolvent, the insolvency practitioner collects the assets, sell them, and at the end distribute the money among the creditors, and at the end the creditor is terminated. This is the winding up proceeding, relatively. But according to this text, I grouped them, that it is not clear whether is it a liquidation, is it a liquidator, who is an insolvency professional, or a person who sells the assets. So I think that this is a big problem. So you should suggest to write into the proposal what is the liquidator in a relative meaning. And the other is the stay. I know what I think I know what the stay means, because in Hungary there is moratorium, and in the moratorium in our act there is written several rules, and within these rules are the stay of execution against the debtor, one of them. But according to these texts, the meaning of the stay is not the same, or the name of the stay is the different. So there are different contents of these definitions, or these words, or it is the same meaning, that only the stay of execution or enforcement action, it relates only for these actions, or for everything. Because according to the American automatic stay, the stay is beginning or continuing judicial proceedings against the debtor, to stay action to obtain debtor's property, action to create. So there are 4 different content of the stay. So I think that probably the meaning of the stay should define. And the other one, I reached the possibility that in our system there is no junior and senior classes. I didn't understand. I know what is it. I think I know. In the American system, there are junior, mezzanine, and senior classes. But in our system, there are no. In the reorganization proceedings are secured and unsecured. It's two classes. And in the liquidation, in the winding proceeding, there is a list of ranks. And there are no junior and according to me, there are contradictions within the proposal, because in the Article 2, paragraph 6, relating to the class formation, the text says that the debtor can create classes, restructuring plan in such a way as to reflect the rights and seniority of the affected claims and interests, but the debtor can use other conditions to create classes. And how can we compare these creative class formation to this question, which was absolutely a relative priority rule, when there are no junior classes, and because other conditions were the basic on the debtor created this class. How can we use this relative priority rule or absolute priority rule? Sorry, that's it is not for SMS, but
can I just ask you a follow-up? I understand the problem with definitions in the directive and how to translate it then to member state situations, and perhaps there may be further suggestions as to how to help with that. But back to SMEs, you mentioned at the beginning that in Hungary, entrepreneurs are not addressed by the law. SMEs, there is no special procedure. In your view, once the directive, if it is being adopted as it is, translated into your regime in some way, do you think then those entrepreneurs, those SMEs existing in Hungary will be covered by the new regime that will implement the future directive?
I'm sure that entrepreneurs know, because the problem is that our legislators couldn't cut into the assets of an individual entrepreneur, because they couldn't cut that this is the assets for the entrepreneurship, and this is your private assets, or your house, so they couldn't do two group of assets. And they said that because we can't group the assets into two parts, we don't allow to go the entrepreneurs into the insolvency proceedings. I think it is not good. There was a suggestion before, but it was refused by the government.
Well, as to the existence of different priorities in liquidation do have and must have some sort of translation into the plan, because I'm sure you will not only have secured and unsecured creditors, you will have first priority, second priority, third.
No. In the reorganization, yeah, no.
In liquidation. Well,
Yeah,
that normally most jurisdictions, that's also reflected in the plan by voting classes. And if you don't want to include classes, what happens is that you simply keep priority creditors outside the effects of the plan unless they agree to be bound by it. But you cannot just ignore the priority fully, because if you do, then all priority creditors, there's a huge incentive to go to liquidation.
But if I understand well, that this cross-class cramdown is not related to the liquidation proceedings, but for reorganization. And in reorganization, there are no ranks, only classes.
But there are in basically all countries, maybe with the exception of Hungary, the creditors the classes are based on the economic value of claims. The economic value of claims is determined mainly by their ranking in liquidation. So it's a translation from liquidation onto the plan.
So,
section, yeah.
And the last remark, that this proposal is based on the voting system. In Hungary, in the reorganization and mostly in the reorganization proceedings, the biggest question is the vote in the voting system that who are the creditors who are entitled to vote, because there are debated claims by the debtor. And have these debated creditors votes? And when
Contingent liabilities, you mean that would, so creditors, you don't know whether there are creditors or not? Is that the case?
they debate because the debtor refuses it, and for example, a trial is gone, and when the reorganization proceeding began. So what will happen with these creditors? And it is binding, an agreement on them. And I think it is the weakest point of this proposal, because it says that, oh, the debtor does that and that with the creditors, but the debtor can create these debated, discussed claims, and they can, and it is binding for these debated creditors, an agreement. So
1 minute to react and then.
Simply that, yes, they will be binding on them.
yes, but with this we can, the debtor can play with this refusement. So in Hungary there was that one day before the reorganization proceeding started, the debtor said that, oh, I refuse your claim, your bank, and you were the biggest creditor in my reorganization proceeding. But unfortunately, I don't accept your claim. I refuse it. Please, you are a debated claim, and the agreement will be binding on it. But I can agree with my familiar, my friend creditors.
No, we understand that, but in case there is a possibility of abuse or a creditor feels that has not been respected, then it can go to court and challenge. What we don't want to do is to have a whole process in which that can happen when there's no reason for it to happen. But if there is a creditor that objects, it can object.
According to this text, what relates to the SMS, I think the best thing is the discharge, the possibility of discharge, because it could help to not only the entrepreneur, but the whole family of him, because the guarantee and the collateral are burden on the whole family. So I think with this help, if it accepted by the European Commission, it can be help to the SMS. So these were my remarks.
Thank you very much.
Thanks. Obviously, we haven't had the opportunity to review it in its full sort of blossoming, but from what I've seen, it seems to me that this has some really excellent ideas. But I think looking at it from the perspective of Greece, it would face a number of problems, because success would have to do with the quality of the administration and of the justice system. So if you in Greece gave lawyers more than one opportunities to go to court to dispute the value of claims, valuations, conduct of directors and so forth, that would probably go on forever. So instead of having an expedited proceeding, you would probably end up with a proceeding that was even longer than the normal one. So I think you have to take into account those national features. And in fact, the less appealing ones are the most important ones in these cases. Greece is a very special case, and I need to explain why in this particular context. It's because of the crisis. I mean, we have thousands of small and micro and small enterprises which are zombies. They really dispense with the insolvency environment completely. They just get abandoned And usually this is combined with perhaps a lease to somebody else, the formation of a new entity that operates under the sort of coverage of the old entity. It's a complete mess. We have a big problem to convince people that they should use the normal proceedings. Management is under pressure, which sort of distorts the motivations to go to some kind of recovery. First and foremost, because they're liable personally, both criminally and civilly, for debts, for taxes, and to social security. So the primary motivation is to get rid of that, as opposed to saving the business. Okay?
So to stop the business is what they want to do.
If you could pay off the public creditors and stop the business, that probably would be the best outcome.
Because otherwise they might make you personally liable.
Otherwise, they'll go after you, your family, your okay. So that really distorts sort of the incentives and disincentives. The other thing that applies to Greece is that most owners and managers are also guarantors. So you cannot deal with the enterprise as economically separate from the owner. You have to see them as a unit. And I'll come back to that. The other problem is the incidence of NPLs. Something like 50% of all bank loans are now in NPE territory. And that's about 100 billion euros. Add to that another 100 billion euros of debts to taxes, and you see that you have a tremendous problem of non-performance.
You said 50%?
50. And last but not least, you have the markets for collateral are very distressed. So you couldn't possibly deal with it through any kind of enforcement because nobody, just an auction or a sale as a price discovery mechanism in such circumstances just doesn't work. Okay? So this is what we have to deal with. And so liquidation is not a credible threat. Bankruptcy is not a credible threat. And you have a difficult negotiation if you try to do it through the normal recovery proceeding. So what we have tried to address is the following. As you said, Nacho, you absolutely have to have a system that captures public debtors. Unless you address the debt to the state and the pension funds, which amount to, as I said, about 100 billion, any recovery effort will be a failure. The second thing is you have to have reliable data. Micro and small enterprises usually do not have reliable data. So unless you are able to deal with this accounting problem, you're not going to have any kind of sensible negotiation because there will be constant disputes and very hard to resolve among creditors and debtors. Okay? And also, you cannot have a big multilateral negotiation because the more players, the greater the complexity, the greater the length, and the difficulty in coming to an agreement. And as I said before, you also have to make sure that you treat the economic unit for what it is. It's not just the enterprise, it's the enterprise, the owner, the owner's house, and so forth. So you have to have something that deals with all of it as a single thing, as a single interest, okay? And of course, whatever you do must protect transactions from challenges. So if you are exposed to clawback or fraudulent conveyancing challenges, you have really accomplished very much. So what we've tried to approach is something which is as simple as possible and as pre-designed. So having something which is a kit that you use without having to sort of design it from scratch. So I would suggest that the system for micro and small would also have to contemplate the use of specific tools and only those. So have, let's say, debt equity conversion, combined, however, with some kind of a stock option plan, so that you allow managers to stay on, and as Nico said earlier, take advantage of the recovery of the business to some extent, so benefit for the continuing support of the entity as opposed to the past holdings. Provide for haircuts and rescheduling, and provide for sale of assets, but not the sale of the business, because I think that's a far more complex undertaking.
Not even as a possibility?
I would say,
if it's too difficult, you just don't use it. No?
I would say not, because this system should not exclude the standard proceedings. So if you want to do something more complicated, you can always go to the standard proceedings. But if you're going to have a simplified system, I think it should be limited to those very obvious solutions and not the fancier ones. And when you have debt equity and sale of assets, I think you need to have some fairness opinion support. And again, specify who's going to provide the fairness opinion and what it has to say. So you have this kit ready and you allow people to use it. Now, we have had 2 bites at this problem. In 2014, I was in fact involved in a very small committee that produced a law. Unfortunately, this part of the law, other parts of the law were successful. This particular part was a failure. And I'll explain what the idea was and why it failed. We said, to meet all of those requirements, we would forget about trade creditors completely. We'd have negotiations which would be limited between the debtor and the banks, and the state would necessarily be, if that negotiation led to an agreement that satisfied certain requirements, a minimum haircut or a minimum rescheduling, then the state creditors, the public creditors, would be crammed down on a pro rata basis. Now, this proration is relatively easy under Greek law because public creditors get 25% of all proceeds. That's in liquidation. Secureds get 65, and unsecureds get 10. So in principle, you can develop an algorithm that tells you if the secured suffer such a haircut, what would the haircut be to the public creditors? So I'm not a mathematician. I should not say these words. Like algorithm, I don't really know what it means, but I've been told. Yeah. But but I think what I'm trying to say is that you can actually have a proportionate treatment, an analogous treatment, if you bring somebody in who knows how to count. So the system would produce the following outcome. Let's say the banks would agree by majority to reduce their claims. And if that reduction was met a minimum threshold, then the state will also automatically reduce its claims as well. Why did we do that? Because the state employees, the public servants in Greece, will never agree to a compromise. Why will they never agree to a compromise? Because they consider that the personal liability may be engaged, because people will think that they've received money under the table to agree to a compromise. So they will never do it. And so if we're going to engage with public creditors, we have to find some way of doing it automatically. Okay? So the idea was that they would automatically be crammed down if certain minimum requirements were satisfied by the agreement. However, that nice idea was shot down by the Ministry of Finance, which said over a dead body on constitutional grounds. So it's not just the Germans, it's also the Greeks.
Public, well, anyway.
Yeah. So, then so that failed. And then 2 years later, under the continuing pressure of the crisis, we came up with a thing called the OCW, which in fact is a proceeding that involves negotiations among all creditors, excluding, however, the 15% of the smallest creditors in value. Of course, in order to determine the 15%, you have to know what your universe is. And to have your universe, you have to know what the accurate data is, which, of course, in the micro and small, you don't. So this is a huge problem, and the system is not working starting from that point. The interesting innovation, however, that this new law has brought is that the state has set up a platform which allows social security funds, the pension funds, the tax authorities, and the banks to exchange information with the permission of the debtor, which means that that platform now gives you, if you limit negotiations to those creditors, it gives you the universe that you need. And on that basis, and with very little dispute, because those numbers are usually not disputed, And if the only affected parties are those parties, then I think you have the environment in which you can easily come to a conclusion, especially if the public creditors are not allowed to agree or disagree, provided that certain requirements are met. I mean, I think we should go back to the original idea, explain why that's the only workable system, but also combine it with the platform, which I think as an innovation is excellent. And perhaps there, one could also involve mediators who are specially trained to facilitate those negotiations, and perhaps some standard plans that they can adjust for each particular case. So my sense is that your idea is excellent. I would introduce a sort of an earlier module of a more limited negotiation as to who the creditors are, and then see whether we need to involve trade creditors, because on the basis of our empirical information, trade creditors usually represent a small part of the overall debt of the micro and small enterprises. So, and the additional element of negotiation complexity and complex in terms of proving claims is not worth the benefit that you would obtain from involving them in the plan. So there are, of course, exceptions, but for those exceptions, my recommendation would be go to the normal recovery agreement and do it the normal way. Or perhaps introduce a simplified second stage, which would draw on some of the very good ideas that you have come up with.
Quick reaction from this.
There is a lot of information. Let me start by saying that Holmes taught us that hard cases make bad law. And if we wanted to adapt the law to the situation of Greece, we'd probably come up with a relatively complicated directive for other countries. And just two elements that you mentioned prove this. The tax, social security, personal liability of directors, which pushes them to paralyze the business, runs counter any basic tenet of insolvency law possible, which is to keep the business running if it has going concern value. So that, or the fact that there is such a big amount of public debt, because you might have an issue there because you're public debt, but at least for a while you were under supervision by the European Union. So public debt was actually something that was managed from abroad because your state owes so much money to the European Stability Mechanism. So they probably wouldn't let you reduce public debt beyond a certain threshold because they would be undermining their own position as creditors, if you think of European states.
I actually personally negotiated that point with the Troika, and they accepted it. Yeah, so that was not a problem.
Wow, bravo. So you're good. Very quickly, you mentioned we have to do anything possible to prevent parties from procrastinating and delaying. Of course, we can only agree precisely the main thrust of our model is to minimize the possibility of that happening and to ensure that at least in a good number of portion of cases, no one really turns up and the thing is very quickly liquidated and got off the way. But we cannot just eliminate any possibility of the parties to appeal or to challenge decisions, only that you just need to include rules that ensure that that doesn't paralyze per se the procedure, so it has no suspensive effect, for example, in case you challenge a claim or you challenge a plan, for example. More, but quickly, we also agree, and we do, I just didn't go into the detail, we provide solutions for situation that Judge referred to before, which is the household component of insolvency of sole entrepreneurs. Of course, when there is a company, usually it is guaranteed by shareholders and directors, therefore it's a personal liability, a personal insolvency linked with the insolvency of the company, and there are cross guarantees, joint and severed. So we know it's the household insolvency problem, and of course the idea would be to include rules to coordinate the insolvency proceedings of all the members involved. And also the discharge would take that into consideration. So that is addressed. Well, I'm not sure if I'm not so sure I would agree with the with limiting the possible tools for the restructuring and the especially with eliminating the going concern sales. You can just not use it. And you mentioned debt for equity and other tools that seem to me perhaps not applicable to the vast majority of micro cases. So if you will limit that to, the possible solutions of micro cases to debt for equity swaps, and it's exactly the opposite. You will not, nothing will come out of that. But we will reflect upon that anyway. Thank you.
Thank you very much. Just to say that Ignacio mentioned that, of course, the proposal cannot be based on peculiar systems like the Greek one or the one in Hungary, but at the same time, the proposal takes into account differences between national systems, and it isn't the aim to have one fully uniform and identical procedure that will be implemented in each country. There may be variations also to take into account of capacity constraints and institutional issues. So before we open it to comments, just to reiterate, because we understand that it is a new kind of concept that is being suggested. It may be difficult to digest it. It is important to reiterate that it is new, but it is based on existing tools that we know. So this is the concept of unpacking what we already have in our systems and redesigning them for SMEs that Ignacio mentioned. By that, what is meant is that we take all those tools that we are familiar with, mediation, out-of-court workouts that you mentioned, liquidation, rescue, the stay, everything is there. We are not limiting it. But at the core, there is this default raw, as you called it, process that is simple, that may not require any significant tools or significant interventions from institutions, but then you can add to that process either as a debtor or creditors, depending on the circumstance of the case. So comments, please.
One. Okay. Well, two comments, but one comment is more an information. We had in Italy the same problem as in Greece about the responsibility of the state employees, and we tried to find a solution. It's very common. It's not only in the field of insolvency. Everywhere that the state has to negotiate, normally the employees ask to have an order for the high levels of the administration. It means you need at least a general director from Rome to approve, and you lose a lot of time. So at the end, the solution was last year. I was in the team who did a negotiation on this with the tax agency, and the agreement was to have to limit the responsibility through the approval of an order of the court. So you have a proceeding where you reach an agreement, and when you have the approval by the court, there is any responsibility for the for the employees, because there is the court approval. It's not written in these letters in the law, but the interpretation is written in a way that the result is this one, and it can work. Of course, is not the best solution, but it needs a long time to change the habit of employees and the way the administration works. The second comment, my sense is that the problem, the bigger problem is what do we understand, we think to be a small enterprise. When the dimensions are really too small, and you'd have the possibility of restructuring or there is nothing to do, the best solution is the discharge and the quick liquidation. And the problem is that also in the directive proposal, the discharge is not so quick as it should be. Many states have difficulties to agree to give the discharge after 1 year or to give an automatic discharge. But this should be the solution in many cases. My experience in Italy is we open too many liquidation with no hope to open the case, only to close the case without any result for nobody. And I think this is really the worst problem for improving the fresh start. And so it could be interesting to have a common notion of a small enterprise in the directive, and in this way it could be avoided that the idea is not possible, and we're discussing a different world.